here two bills, House Bill 310 and House Bill 328. Those are both part of Governor Deal's this year's criminal justice reform package. What we're going to do, and this is hearing only for both bills, just to make sure that's clear, what we're going to do is have House Bill 310 first. We'll ask Chairman Powell to go ahead and go over the bill with us and whoever else he has with him. I think Thomas Worthy with the State Bar, Governor's former Deputy Executive Counsel and actually Chairman of the Criminal Justice Reform Council currently as well. I think I've said that right, Thomas, haven't I? Or close enough. To be there to support. What Chairman Powell is going to do is go through the bill with us, and then I think what we'll do is ask Chairman Powell just to go through the bill at his discretion, however he wants to do that, and then we'll probably do member Q&A, if any, at the end. If someone explodes and just can't wait to ask a question until the end, then maybe we'll entertain that, during the time, and just, you know how it is here. It's just more of a dialogue than anything formal, and we seem to have a more productive outcome because of that. And then Representative Efstration, right around 3-ish, is going to go ahead and present 328, same format, members. He's going to go through the bill. We'll have Q&A. And this is our opportunity really to get to really the heart of a bill, the intent. Obviously, we're all familiar, whether you were here last year or not. Representative Reeves and Representative Trammell, both outstanding additions to the committee, weren't here, but they certainly are familiar with criminal justice reform. This is the next iteration of that. I feel we have a large investment in this legislatively, maybe even emotionally, in the work product that we do here, because we've seen already the results dating back from the first bill, which was 1176, which was just a few years ago, but we're already seeing the benefits of that in terms of public safety, the budget, and other considerations. So with that, turn over to Chairman Powell. Thank you for your role in 310 and continuing our efforts, our collective efforts and collaborative efforts on criminal justice reform. And I'm hoping that microphone is now on. Let's find out. Let's try it again. Oh, press the little thing on the bottom. Now try.
Now is it? Yeah, there you go.
Good.
Thank you, Mr. Chairman, and ladies and gentlemen of the committee. I bring to you today House Bill 310, and the chairman of the committee said it exactly right. But there's a lot of people that this product deserves a lot of thanks to. First and foremost, the governor of this state. I've been very outspoken for years. That back in the 90s, when we were getting so tough on crime, it was the thing to do in those days. And then we saw over a period of years that we saw the changes, that we had not been exactly the wisest in the world by being tough on crime, because we hadn't been smart on crime. Governor Deal has identified a lot of those problems during his first 4 years in office, and that's getting smart on crime. And as the chairman had said, we've seen the positive benefits of the legislation he's passed so far. House Bill 310 is just furthering that to the next step. House Bill 310, that the governor's idea, has been promoted for several years. Several of us have been talking about this for years. Jill Travis, our most able legislative counsel, she's drafted this bill in some shape, form, or fashion over the last 10 years or so, or maybe even longer. And she's put an enormous amount of work into this piece of legislation. To the committee members, I will tell you that this, while it looks to be a voluminous bill, quite frankly, probably 90% of this bill is only plugging and unplugging. It's current code. It deals with several issues. I'll give you the gist of it. This creates a Department of Community-Based Supervision, and this pulls from existing state agencies. The Department of Community-Based Supervision, it will take the parole services from under the Department of Pardons and Paroles. It'll take probation out from under the Department of Corrections. It'll take those functions of juvenile community-based supervision out from under that, and it creates all of those into a one standing department. And as I was told, and as the governor had said, and a lot of us had said over the years, what you have is a situation in this state where sometimes you have parole officers meeting the probation officers coming out of the same house, or the juvenile probation officers, or you have DFACs, or you have different folks that are paying, that are coming in and out of the same home. So why not do a concerted agency that they could be able to deal with all of these issues and cross-reference? A few years ago, we started doing cross-training between parole and pardon and paroles and probation services, and that was only a start. But this creates this division for community-based supervision. So I'll tell you again that 90% of the bill that you see in front of you is only plugging and unplugging from existing state law. The only changes have been technical changes. The gist of it, this bill establishes an 11-member board, and that may be at the will of this committee, may be expanded even further. The board is this board would be created by members from the Commissioner of Corrections, the Chairman and Vice Chairman of the Parole Board. Some of the freestanding agencies, DFACs, would be represented on this board. Then there's specialty judges, those that would be put on the board as appointed by the governor. The judiciary is well represented on this board since community-based supervision is part of the criminal justice reform. Reentry would be moved. The GOSTAR, or the Governor's Office of Reentry, would be codified, whereas right now it's only done by executive order. They would be administratively attached to this agency. So it all fits into place. Everything that would be community-based supervision, whether it be reentry programs or otherwise, and they'd all be under this agency. The other part that's quite frankly, that's of a special nature that needs to be dealt with was the legislature last year, because of a lawsuit and a judicial order that dealt with private probation. For misdemeanor probation, the General Assembly, we passed legislation last year, and the governor promptly vetoed that legislation, as probably he should have. We have dealt with fixing those problems. The governor's council on criminal justice reform had some 13 points of interest that they decided that needed to be dealt with on private probation. In this bill, those points of interest are taken in. They're dealt with in a very specific manner, and that's probably the most substantive changes that's involved in here. As you look through the bill, there'll be a lot of things in here that you'll see that doesn't make a lot of sense. You'll see things that deal with vending machines. You'll see things that deal with badges. These are all things that are germane to that specific agency. Vending machines, it was where their monies that went for, like in the probation offices, they went to the flower fund. Well, all of those had to be combined. That's the reason that the work that Ms. Travis did was just so monumental that she had to pick and try to find all type of things that needed to be moved under this by moving it from code section to code section. And that's generally what this bill does. Be glad to stand for questions. I also have Mr. Worthy, and he's more than capable, probably more capable without a doubt than I am, to answer specifics, especially as it relates to the private probation.
More capable than me as well, from I understand.
I doubt that, but
certainly
more than me.
I think the private probation, I think the consolidation piece is pretty straightforward, and that's just speaking for the chair. The governor was first elected. He was given the opportunity, and the people said, we want to hear your vision on X, Y, and Z. Well, X was criminal justice reform, and put forward a program that came through this committee by, I think, almost in total through his first term, and the people came back last year and said, we approve. And so this is now And to me, that spells it's a referendum, right? It's a referendum on a particular agenda and approach, and they said, yes, we approve on that. And so I think now, having been approved, a second time, we now, have the governor has the opportunity to implement the second big chunk of his vision on how to make, I wouldn't say competing offices and departments, but to drive efficiencies where he can for the betterment of the system. And I think, that referendum from last year is the opportunity to go ahead and implement that vision. I think that's really what it distills down to. On the private probation piece, I think it would be helpful, either you or Mr. Worthy, whatever works, to walk us through the specific changes. That's obviously gotten some discussion, both internally and externally, and talk to the improvements that the governor that he envisions and wants to implement, and the differences of what we're seeing now and then what we would see when this vision gets implemented. Is that reasonable?
Sure.
Okay.
I'm going to call Thomas up, and I'm going to go through it, or he may wish to go through it.
I'll do it line by line.
Let him do that, and that way I won't be redundant with it.
And, and Mr. Worthy, just in terms of what we're looking for is, as always, it's here's the issue, and here's the potential, here's the problem, and here's the potential solution, and here's why. And we obviously we have limited time. It's not that limited, but to the extent, however you want to do that from a high level or medium level, I'll leave to your discretion.
Thank you, Mr. Chairman. Chairman Powell, Chairman Golick, thank you to the members of the committee. What you see here, many of these folks in this room have done yeoman's work along with Judge Mike Boggs and the 15 members of the Criminal Justice Reform Council, as well as Ms. Travis. And the private probation, or I'm sorry, the misdemeanor probation recommendations contained here in this bill, I am very pleased and proud to say represents a consensus-based recommendations. Ever since the governor's veto of HB 337 last year, plus the December 2014 audit of the misdemeanor probation recommendations, as well as the Supreme Court's decision in Sentinel Offender Service versus Glover, all those three items kind of came together and indicated that something that needed to be done on misdemeanor probation. And the governor asked the Criminal Justice Reform Council to look into it. After discussions and thorough vetting of the issue with the misdemeanor probation industry, with the human rights organizations, with SIMPAC and AOC, and everybody in between, we came up with 13 consensus-based recommendations, of which 12 require statutory change, and one of them is an administrative change. I will go through those quickly here and then answer any questions. The first recommendation goes directly towards transparency in misdemeanor probation. And our recommendation required that providers issue annual reports to the local governing authorities, as well as the judge using their services, summarizing the number of offenders under supervision, the amount of fines, statutory surcharges, and restitution collected, the amount of fees collected for probation supervision, the number of community service hours performed by the probationer, drug and alcohol testing, classes and rehabilitation programs, and any other service for which the probationer is required to pay money. And we further recommended that the report shall be subject to the Open Records Act once they are received by the local governing authority, and also requiring the local governing authority to timely post that on their website so that people can have access to that without even going through filing of the open records request. That's contained in lines 1208 through 1234 of the bill. The second recommendation goes towards transparency also, but this is directed at transparency for the actual probationer. Our recommendation stated that probationers shall be provided with receipts and balance statements at every single appointment with the probation officer. It also requires that probationers shall be entitled to receive a one-time copy of their supervision file. It's important to note here that there are obviously things within the supervision file, such as victim information, that does not need to go to the probationer. The new department would promulgate rules and regs on how to redact that and what would be allowable to go to the probationer and what needed to be redacted out of the report. However, the bill would provide for an in-camera inspection. Lines 960 through 1008 of this bill is in response to the Supreme Court's decision in Sentinel Offender Services versus Glover. The Supreme Court held that there was no statutory authority to toll misdemeanor probation sentences in existing law. So following our recommendation, this bill creates the statutory authority for tolling of misdemeanor probation sentences. It also includes notions of due process to ensure that no tolling takes place without notice and an opportunity to be heard. Lines 816 to 818 codifies what is common practice in many municipal and state courts around the state already, and that allows for probationers who are unable to pay fines, statutory surcharges, and probation supervisions fees, that those financial obligations can be converted to community service at the rate of federal minimum wage or higher. There are some judges in the state, Judge Jackson being one of them in the Atlanta Municipal Court, that allows for a higher rate, but we say at the bare minimum, federal minimum wage rate should be in the law. Lines 863 through 881 codifies the authority to waive court-imposed monetary obligations or convert to community service if the probationer is indigent, and it also mandates a Bearden analysis, which Bearden versus Georgia is currently case law and requires a court to inquire into the indigency status of the probationer, but this puts it in the code. That goes hand in glove with the previous recommendation, and that's at lines 863 to 881. In lines 819 to 846, this creates a rebuttable presumption of the probationer's indigency under circumstances already outlined under existing law. The factors that create the rebuttable presumption are already in the law. It includes mental illness. It includes, a certain amount of time since incarceration. We did not come up with new factors. We used existing law, but we also recommended that presumption can be rebutted by a preponderance of the evidence. So even though they come in with a presumption of indigency, if they meet some of those factors, if the judge inquires and realizes that the probationer is buying alcohol or has some other means to pay their monetary obligations, it is a rebuttable presumption with a relatively low bar to rebut that presumption. That's at 819 and 8 through 846. Lines 864 to 876. This brings misdemeanor probation violation penalties more in line with existing law for felony probation violation penalties. So what the council recommended and what this bill codifies, that if a probation violation is merely failure to report or failure to pay and not a violation of another term of probation, the maximum confinement would be capped at 120 days before or the remainder of probation, whichever is less. Before, if we didn't address this, the way the Misdemeanor Probation Act reads, you could in fact have up to a year for every violation, and the judge could do that on top of each other. So you could in fact, under existing law, have a situation where a violation of a misdemeanant's violation of probation could impose a longer confinement than a felony violation of probation. So this caps failure to report or failure to pay at 120 days or the remainder of probation, whichever is less. In any other violation of the general provisions of probation would mirror the felony statute, which would be confinement for up to 2 years or the remainder of probation, whichever is less. But that differentiates, which is, in the council's opinion, very important for those cases that are merely failure to report or failure to pay. Lines 882 through 897 defines the concept of pay-only probation and caps the amount of supervision fees that private providers are allowed to collect for pay-only probationers at 3 months. We really thank the industry for coming a long way and helping us work out this recommendation. The concept of a pay-only probation case would be a case whereby it's a super speeder fine, and the fine imposed by the court was $250, $300, and they couldn't pay at the time of adjudication. They can be placed on probation and have a payment schedule to pay those fines to the court. This is saying that for those pay-only cases, which is very clearly outlined in the bill, the amount of supervision fees collected by the private providers would be capped at 3 months instead of however long it takes for them to pay their fines to the court. And then lastly, lines 1137 through 1207, it moves the County and Municipal Probation Advisory Council, also known as SIMPAC, from the Administrative Office of the Courts into the new Department of Community Supervision. This will really explain to the committee why the council's private probation recommendation or misdemeanor probation recommendations are included within this bill. It prevents double drafting. As you can tell, in this area of the code, there's so many cross references and cross sections, so everything needed to go into the bill for efficiency's sake. This would move SIMPAC from AOC to DCS, and while the DCS board would promulgate the rules and regulations for misdemeanor probation providers, it would also have a SIMPAC-like board to serve in an advisory advisory role. That's at 1137 through 1207. That concludes the presentation of misdemeanor probation recommendations specifically. I do want to reiterate the council's appreciation to everyone that has helped us along. This has been a very, very monumental task, and we are appreciative for the input from everyone that has lent their expertise to the Georgia Council on Criminal Justice Reform. And with that, Mr. Chairman, I'll give it back to Chairman Powell or answer any questions the committee may have.
Thank you, Mr. Wardy. That was a valuable summary for us, especially on the private probation piece. I wanted, and I should have said this earlier, but you have a summary, members, in your member files that was written by our committee aide, Connor Bateman. It's an outstanding summary of a pretty bulky bill. I mean, as you might expect, there's going to be a substitute when we go ahead and when we get to the point of taking a motion, but the summary that Connor put together is outstanding, just as a resource. Also, there was a late handout that the AOC gave me that came in. The top caption said immigration consequences. That was from the Council of State Court Judges, just by way of information, and that was asked to be passed out, and so we did, and that's for your just for you to consider and review as per their request. With that, let me ask and see if members have any general questions, specific questions on any of the on any part of the proposal as described by Chairman Powell and Mr. Worthy. Mr. Hightower.
Mr. Worthy, and I may have missed it. What section did we directly address the tolling issue that I know was brought up?
That's in lines 960 through 1008.
Okay. Thank you.
I'd be remiss if I didn't thank Representative Pack for his service on the Criminal Justice Reform Council. Thanks.
Yes,
Thank
you would be
for your
remiss,
help.
and I thank you for doing that. I appreciate, just a comment. I appreciate the piece on the limitation on the fine. That, as you described it, obviously we've had conversations, and I've spoke with Judge Boggs about it at length several times on just sort of what I'd call the churning effect of that probation and the fine. I mean, at some point it just keeps on revolving and revolving, and it just reminded me of a title pawn, gone terribly awry, of just and just never being able to get out from under. So I think that's an incredibly important reform. Not that there shouldn't be that accountability, there should. Right. But at some point, when is it not meeting the intent of the statute? When is that system? And that's a pretty kind way of putting it. I mean, there's a lot more realistic, perhaps even harsher way I could put it that I won't do today. I think those who may, feel some angst about that reform might want to consider that could have been significantly more ambitious, and that may come, in the future. But I think this is a good, first step at reforming, and it's a true reform, in my mind, a gigantic step forward. And I think that was important to say out loud. Other questions from members of the committee? Going once? Representative Ballinger, you have a special guest with us today. Would you like to introduce your guest? This is Henry Ballinger, everyone. Thank you for joining us, Henry. I love that. Mr. Pack.
I would also be remiss if I didn't commend the co-chair of the council. I know Tom, Mr. Worthy, has devoted countless hours of his time, along with Judge Boggs. I think that I know there's been a lot of press about Judge Boggs because of what happened with his nomination, but the work that he's done and the dedication he has to the issue, it's just, if you see it at the level that I had a chance to look at it, you have no doubt that Judge Boggs, it would have been a tremendous, I think, member of the judiciary and the federal bench. But I don't control that. But I wanted to commend Mr. Worthy as well, and two co-chairs have devoted a tremendous amount of time, and because this is a huge step forward of ending what I will consider to be, at times that the chair has noted, a debtor's prison, a system that I think some probationers had suffered because they're on probation. They have to go to work. If they go to work, they miss the probation, they get revoked, and there's more fines. So the conversion to that, to community supervision and volunteering, I think is very, very important, and I think it's a great step forward. Thank you.
Thank you, Mr. Pack, for those comments. I appreciate that as well. I had the pleasure of sitting next to then Representative Mike Boggs in the House for 4 years, and I can tell even then that when something wasn't working in the system, it just drove him up the wall. It really did, and he really was a passionate advocate for that kind of reform. I think we just needed a platform to do that, and that platform was really honestly provided by Governor Deal. That's the truth. And so we're someone like him who can clearly speak to it from a practitioner's standpoint, from having been a Superior Court judge, and then of course Mr. Worthy's role as a deputy executive counsel, and then also as executive director of the State Bar, and does the Criminal Justice Reform Council on the side as a hobby.
Not executive director. I don't want that job.
Head of government affairs for the State Bar, which is actually a heavier lift than the job of executive director, and you could tell him I said that. But to do all that and to juggle it and to juggle it well. And again, I've had those conversations with Judge Boggs a lot of times now, and the passion is there, and that's what you want to see. And it's just a real drive to make the system better. And that's we need more of that. Any other questions from members of the committee? Mr. Hightower.
Mr. Chairman, this is what happened when you get good guys from Carroll County to lead things. So,
I think it is a Carroll County thing. I think I agree. All right, gentlemen, thank you. I appreciate it. I told Mr. Efstration to be back here in 20. Or I asked Representative Efstration to be here in 20 minutes to speak to his bill. I think since we have a few minutes, if there's anyone who'd like to be heard briefly, if you would, because we do have 20 minutes until Representative Efstration's presentation. But if anyone would like to be heard, this would be the time to come forward and be recognized. There's no sign-up sheet, so if you want to if you want to come on up, and if you would let us know who you are and who you represent, and if you could limit yourself to just 2 or 3 minutes, we'd appreciate it in case there might be a question from the membership.
I will be very quick. Yes, sir. My name is Wes Taylor. I'm state court judge for Fulton County, and I am legislative chair for the Council of State Court Judges. And I am here. I think you've already got the handout as to the language in the bill that may inadvertently, because of language in federal law, cause some issues with folks who are legally here, and it may have may cause some problems with their immigration status. So we brought that to your attention. So I don't need to belabor that, do I? Or do you want me to talk about it?
If you wanted to touch on a highlight or two.
Okay.
to roadmap the issue on us for us, so that we and frankly council as well could, just for purposes of awareness, so that when we do
Yes, sir.
cobble together the sub, we can do it from some level of knowledge.
Yes, sir, will do.
Okay.
Very quickly, federal immigration law, by statute, really codifies what is a felony sentence. And the issue is, if it is a sentence that could be in jail time or construed under federal law as jail time, even if it's probated, that is a felony under federal law. And so folks could be deported based upon that felony conviction, which in Georgia is a misdemeanor. And everybody knows as a misdemeanor. And so the language that has been suggested that I think is in front of you is a way to address that without altering the intention of the bill and what's there. So that's what the idea is there. I will bring to y'all's attention, because I'm not sure whether it's in front of you, lines 799 to 800 of the bill, which talks about the period of probation shall not exceed the maximum sentence of confinement. That could possibly cause an issue with another code section, which is OCGA 19-10-1, subsection J, as in Jimmy. And the reason for that is it's about abandonment issues. You can suspend a sentence until a child reaches the age of majority. I'm not sure it would cause an issue, but if you want to take the most conservative approach, y'all might want to consider excluding specifically OCGA 19-10-1 out of that provision, just so that that's not shortened from what it is and there's not conflicting law. The other piece that I would like to bring to y'all's attention is in, and by the way, I did want to continue the love fest of Judge Boggs, even though I am sorry as to what happened for him on the federal side. I can tell you, as trial judges, we're all kind of happy that actually he's stuck around for the Court of Appeals. So actually that's good for Georgia, even though the process wasn't as what most of us would like to see. But anyways, with this, the one section that I'll bring to your attention is 42-3-2, lines 75 to 90, and that's the makeup of the Department of Community-Based Supervision. And the one thing that we would suggest or request is that a state court judge also be appointed by the governor as to make up, we're not talking about exchanging anything out, but right now you have juvenile court judge and a superior court judge. And quite frankly, they're not necessarily focused on misdemeanors. And the state court was created specifically to handle misdemeanor criminal matters. And so, and we're the court, while we don't have the most criminal or folks on misdemeanor probation, I think that's municipal court judges. What we do is I think we handle the widest variety of misdemeanors. And so I think it would be to the benefit, since this bill specifically deals with misdemeanor sentences and folks are focused on that, it would probably be helpful to have a state court representative on this department so that you could bring a voice of folks who actually deal with misdemeanor probation on a daily basis. That's it.
Thank you, Judge Taylor. Questions for Judge Counsel? Do you have something? Yes, ma'am. Yes, ma'am.
The language that is being complained about on the pages in the memo is current law. And it appears in the bill on 713 through 721. So this is a current law problem as opposed to a
And what,
problem?
well, how that's, I think, addressed is the sentence form and how it's dealt with. So yes, it is more or less an issue, whereas the Superior Court judges, under their form, and most state court judges now have changed their forms as well to make it so that the defendant is sentenced to a specific amount of time in jail, and then that to be served in jail and the rest to be on confinement. So it's not really we sentence you to a 12-year period in jail and then we're probating a portion of that. It's a different, yeah.
Yeah, I'm familiar with the issue. It's just that all we did was carry forward current law.
Right.
And
This
I
is,
just wanted the committee to know that that wasn't the change that was made by the author.
It is something that, right, it could be, and I'm just saying, I wasn't accusing you of doing anything. I'm just saying that the way that we have it now, like for instance, if somebody comes in who's here legally, their counsel, in all likelihood, will ask me to probate it for some period of time, less than 12 months. So like on a DUI sentence, which carries a required term of a year, often judges around the state will go to 11 months and 29 days just so that you don't run into that immigration issue, which is more of a possibility, but it has occurred for folks, and you've had to go through the process with the federal government and federal immigration authorities. So this was just a suggestion that we might clean it up in this bill, since we're already addressing it. Might be a good place to do it. And not accusing anybody of doing anything
No,
wrong.
Judge, we
It was
appreciate
just-
that. The cleanup that we do here, that we do on the front end, helps a lot on the back end. So
Yes, sir.
we'd rather have that presented to us as a possibility, and then we can, exercise our discretion, but we'd
Yes, sir.
rather know. So thank you.
Yes,
Mr.
sir.
Pack.
Quick question for legal counsel. I don't know if this happens in the other code. I noticed that the judiciary members here that's appointed on the board has power to promulgate rules. Do we run into any separation of powers issues?
The BCS being.
No, yes, BCS.
The BCS being able to promulgate rules and regs. I'll take a look at that
Yeah,
issue.
because I think the issue came up in the context of the federal law. There was, I think it's I can't remember what it was. It was in any event, I'm just flagging that because I never. Advisory committees, I think, generally are okay because they're not making rules. But I know we're giving this department some rule-making power, which I would propose that one person, a probationer, challenging it, like a state court judge, and the person who's serving it might be disqualified from sitting on any cases that touch upon the rules.
At least in the beginning, it's going to be the rules that are in place now
Right.
that are going to come forward for all these different
Right.
agencies. But that's good.
I just flag that. Just want to make sure that we don't get the whole thing struck.
Yeah, that's the name of the game. Is it's not,
I hear you.
it's not to be struck down.
Agreed.
That's the first priority. Any other questions for Judge Taylor? Judge, thank you for being here.
Thank you.
We
And the
appreciate your.
council, by the way, applauds all y'all's effort and the committee's effort on this matter. We are in full support, so we're excited about this. So thank you.
Thank you, Judge. Appreciate your engagement on the issue. I see Judge Gary Jackson from the Atlanta Municipal Court. Thank you, Judge, for being here. I see.
Probably head over to General Duty Committee for 377, but I would echo Judge Taylor's remarks in that it's been a lot of work. Judge Boggs was a tremendous leader, and we as a municipal court judge, and I imagine magistrate of probate, who basically see these probation cases. I understand there is some talk about putting us on the board itself, so we would have some input in this case. That may be a thought.
Thank you, Judge. We appreciate your being here. And Judge Boggs, I think, would have been here. He's in South Georgia, and he's a lot warmer than we are right now. I see Judge Matt Crawford loitering in the back. Thank you, Judge, for being here. It's good to see a former member of the House of Representatives. Would anyone else like to be heard on House Bill 310? Yes, ma'am.
Catherine Bernard, attorney, appearing privately.
Sure. We've got about 10 minutes, so let me again ask you to just, if you could take 2 or 3, and then if we have any questions, then we'll take a very quick break, members of the committee, in time for Representative Efstration to come and make his presentation. Yes, ma'am.
I'll try to be brief.
Okay.
Thank you, Chairman and members of the committee. I'm Catherine Bernard. I am an attorney. I have practiced as a full-time public defender in the Dublin Judicial Circuit for 4 years. I am now employed as a conflict public defender for the Standards Council. So I am not here on behalf of the Standards Council, but I have done a lot of probation revocation hearings, know a lot about probation cases from all around the state, and have dealt with this subject very intimately. I do appreciate what you are trying to do with this bill. I find myself in agreement with the points that have been brought up by Mr. Mr. Worthy and others, dealing with misdemeanor probation tolling, ways to avoid misdemeanor probation becoming a debtor's prison and a cycle. I think the chairman's analogy regarding a title pawn is very apt indeed. You do get individuals who may have a minor fine, they get stuck in a circle of failures to appear, failures to pay, and we end up spending a lot of money to make their lives worse, and it doesn't help anyone at all. So I think these are all commendable goals, and I'm glad that we are accomplishing them through legislation. However, what was not discussed during the previous speakers was what exactly this Department of Community Supervision is going to do. And from what I have read in the bill, I'm afraid that it represents a troubling expansion of not only executive power, but also legislative and judicial power, all combined in this Department of Community Supervision. I brought out, there are a couple of points that I did note, which of course I know you've all reviewed the bill, but the big concern is the DCS commissioner, someone who will be appointed by the governor, has tremendous authority far beyond what would be needed to affect the changes that have been discussed today regarding misdemeanor probation tolling, community service, which, by the way, that is something that many judges around the state are already doing, allowing people to perform community service in lieu of their fines and fees. However, this commissioner would be able to establish any and all units for the Department of Community Supervision. There's no guidelines whatsoever on how many of these units there would be, how many assistant directors there would be, or even what they would do, except for one reference to there does need to be one victim's assistance unit. Other than that, we could find ourselves dealing with 5 subunits. We could find ourselves dealing with 50 subunits. There's no guidance whatsoever in the bill, and I think that a bill that has been worked on by such august legal professionals should be able to provide a little bit more guidance than the commissioner can simply appoint and create the units for whoever he or she likes. There's also some concerns about the authority of this individual to confer the powers of police officers on employees. And this is line 191 in the bill, and it's one of the most troubling. It would allow the commissioner of DCS to confer on any employee of the Department of Community Supervision full police arrest powers to arrest on site, to carry weapons in the locations that only law enforcement are allowed. And there are no restrictions on this except for what is otherwise provided in the statute. This is a tremendous expansion of power that would basically make the Department of Community Supervision into potentially the largest law enforcement agency in the state of Georgia. And my concern is that that's not being discussed. If that's something that we do need in order to affect these changes to misdemeanor probation, let's put that out front and center so we can talk about it as a community and decide if this increase in power is going to serve the needs of those within the criminal justice system and those outside of it who are concerned about public safety, as well as general employment in the community, the stability of the family, and every other aspect of life that has been affected by our criminal justice system and its growth and over-criminalization. It also, right after line 191, it would authorize the commissioner to authorize certain persons to assist local authorities in preserving order and peace. I'm not really sure what that means, but again, it's a tremendous expansion of power that we are giving to the Department of Community Supervision with very little discussion. There's also not been much discussion about 42231, creating the Governor's Office of Transition Support and Reentry. This would also be a position where the director would be appointed and serve at the pleasure of the governor, with a salary to be set by the governor, a staff to be set by the commissioner. This would be one of those quasi-executive agencies that operates partially under the authority of the legislature and partially under the authority of the executive. But what's troubling about this is that apparently the Governor's Office of Transition Support and Reentry has already been operating. As early as October of last year, we were receiving federal grants and funds on criminal justice reform in the name of the Governor's Office of Transition Support and Reentry. So the concern here is what legal authority was that transpiring under in late 2014, and why do we need to make it into an entirely new agency if it has already been operating and successfully been able to get any federal grants and funding that would be needed? So I think there's more discussion needed on this entirely new office, again, of transition support and reentry. This board would be authorized to solicit and accept gifts, grants, property, and again, this is a fairly large expansion of power that would cost a lot of money. And that's the other issue. How much is this going to cost? We're dealing with the criminal justice system, so it's not something that we want to try to make revenue neutral, as much as that may be the goal. We have to recognize that these are often very poor people in very difficult circumstances who are getting placed on probation. We can't expect them to cover the cost of their own supervision. Realistically, it's just not going to work, and it's going to create a distorted incentive system within the criminal criminal justice system. One of the things that we need to note is line 176 that does state that no employee of the Department of Community Supervision shall be compensated on a commission or contingency basis. That's fantastic. It needs to be expanded so that no contractor is able to be compensated on a commission or contingency basis either. We want to avoid any kind of incentive whatsoever for keeping Georgians locked up. We have to realize Georgia has the highest number of people on probation as a proportion of our state in the entire country. It was 1 in 13 at the last time it was measured. I recognize that there has been some positive impact from recent criminal justice efforts. There have been some accountability courts that have been developed. However, as someone who observes these in practice, they often seem to be targeted at people who don't necessarily need to be under the supervision of the state in the first place. There are also serious due process violations involved. I would cite to the committee lines 616 through 640 of the current legislation that would create basically a quasi-judicial authority within the Department of Community Supervision, wherein individuals who were charged with a violation of probation would not have access to a magistrate judge, a superior court judge, as they currently do, and instead they would simply be assigned to a hearing officer within the Department of Community Supervision, and that person would be impartial, but they're still going to be an employee of the Department of Community Supervision. The idea that one of these individuals is then going to be a completely impartial judge of the people that they're supervising, really it beggars belief. And then, even if there is an appeal process, that appeal still goes to someone within the Department of Community Supervision. So we are basically creating 2 additional layers of quasi-judicial authority within the Department of Community Supervision. I can tell you already that there are courts all across this state have full days of probation revocations. It's the bane of every judge. They have to deal with dozens of them every single day. And it's very trying. It's trying for the lawyers who are involved. It's trying for the judges, certainly for the prosecutors. And what I would ask is for this committee to consider if there are ways to solve this problem that involve reducing the size of government rather than increasing it through the Department of Community Supervision. Perhaps we could look at the fact that Georgia is one of the only states, perhaps the only state, where traffic citations such as speeding actually constitute misdemeanor crimes for which you can spend a year in jail. That is extremely unusual throughout the country. So maybe we could look at the way we are dealing with our misdemeanor cases and the volume of cases, the percentage that involve victimless crimes, that would be appropriate. So we also have to deal with the
Ms.
mental
Bernard, I'm
health
going to ask
issue.
you to wind up because it's been a little more than a few minutes, but we run an open process here, and
Absolutely.
I do that across the board. Mr. Frustration is here, and I just need you to wind up if you could. I apologize.
Oh no, I'm happy to do that. It's a very long bill, and so I apologize. I could be on my soapbox forever about this, but I do hope that the committee will consider these. I'm happy to send an email summarizing all of this to the members of the committee as well. But I would ask that in our excitement to get the good aspects of the bill, which I do agree with Mr. Worthy, Judge Taylor, and the others who have spoken, there are wonderful things in this bill. The Department of Community Supervision, as a gigantic new state agency, is not one of them. Thank you.
Thank you. All right, that'll end our consideration temporarily on House Bill 310. The committee will not really begin the process. I'm sure a sub is already, in the works, but the goal will be either on Monday or Wednesday of next week, just depending on what issues come up and when, and council's ability to juggle everything else. See if we can get to a motion at the very latest by next Wednesday, which would position the bill for day 28. The chair doesn't like day 29 or day 30, especially on a big ticket item like the governor's criminal justice reform package. So 28 is a safe day, and we'll shoot for that, if not sooner, frankly. So we'll shift gears from that. We'll recognize Representative Frustration to come forward and speak to House Bill 328. And Mr. Frustration, what we'll do is ask you to go through the bill as you see fit, hitting the broader themes, the motivations for them, and then we'll take questions from the committee, and then we'll hear from any interested parties that might be out there, and it'll be the same exercise, and we'll go from there.
Thank you, Mr. Chairman. Mr. Chairman, I'm operating off of LC judiNon022615EDITED today, a committee substitute that's been provided. Just want to make sure everybody had the same copy. Mr. Chairman, consistent with the testimony that's been offered previously today, this bill contains aspects of proposals made by the Georgia Council on Criminal Justice Reform and the recommendations that have been made. I'll just take it in order. Section 1 deals with portions of the report that discussed concerns about failures to provide accurate reporting of a convicted individual's criminal history, or somebody that successfully completed first offender and is not a convicted offender being inaccurately reported as part of agency reporting. And this would provide, as part of this legislation, would provide a course of action for those individuals that maybe successfully completed first offender but are suffer adverse consequences as a result of failure in reporting to have recourse. Section 2 deals with, and the next few sections really deal with, all contained within Section 2, is consistent with a recommendation made on page 20 of the committee's report, the possibility of parole in certain offenses or in certain convictions where parole was not previously possible. As the committee is aware, under OCGA 17-10-7, I believe it's the recidivist statute, if an individual is convicted for a third or subsequent offense, that it's possible for the prosecutor to seek a status where parole is not an option, and the sentence must be served to the day. Mr. Chairman, this provision, Section 2 here, would allow for parole in certain circumstances specifically defined. First of all, recidivist treatment must have been sought in a VGCSA offense under 161330. We'll note it does not include any trafficking offense, but in certain controlled substance convictions, an offender would be eligible for parole where the sentence was made under the recidivist statute if certain conditions are met. You'll see those conditions listed in Section 2-2. First of all, the individual cannot be a convict of a serious violent offense. That further, the convict cannot be previously convicted of any sexual offense where reporting is required, cannot be convicted of aggravated assault or possession of a firearm. That could be during the commission of a felony or by a convicted felon, but an offense involving the possession of a firearm. Additionally, there would be requirements that the convict serve at least 12 years of the sentence as given by the trial court, that the convict have a low risk for recidivism in the evaluation that's made by the Department of Corrections. And, Mr. Chairman, it's important also to mention that overall here, the Board of Pardons and Paroles would have the ultimate decision about what takes place. This just restores discretion that was previously taken away under the code. Further, under, this is line 17, additional diagnostic and rehabilitative programming is provided within the Department of Corrections. Within the 12 months preceding consideration, there to have been no serious disciplinary infractions. And finally, that a high school diploma or GED is obtained by the individual seeking this status. So these are very rigorous structures and a framework that's been put in place to, as I said, allow pardons and paroles to make a consideration of parole under these circumstances. And the goal here is inconsistent with the principles of criminal justice reform is to identify people with a drug addiction that have had very serious or significant sentences under the existing recidivist statute, and to provide discretion in the possibility of parole in certain circumstances to eligible individuals. There's section 3-1, Mr. Chairman. That is, there are additions consistent with the with a license that would be created for individuals that have satisfied or are undergoing a first offender treatment. And I believe that's to be used in conjunction with employment opportunities. Mr. Chairman, in Section 4, as the committee is aware, in criminal justice reform, many of the dollar thresholds for misdemeanor to a felony were increased in previous legislation. However, one offense that was missed is covered in Section 4-1, and the threshold is raised from $500 to $1,500, similar to the theft by taking threshold that was increased previously by the General Assembly. In Section 5, the proposed legislation attempts to implement many of the successful reforms that have been put in place and allow greater oversight with regard to the Public Defender Standards Council. And that's followed in Section 5 here. I'm happy to answer any specific questions, but this deals with allowing greater discretion in the operation and following through with the successes that have been seen. Section 6, Mr. Chairman, is along the same lines with the oversight and allowing greater discretion with regard to the Public Defender Standards Council, which would be the title would actually be changed. The name will be changed to the Georgia Public Defender Council as part of this bill. So in summary, Mr. Chairman, the legislation as proposed would allow for reforms consistent with the goals and objectives of criminal justice reform, and I'm happy to answer any questions the committee might have.
One observation on the partisan parole piece that I think that'll Representative Tanner has House Bill 71, which is a good piece of reform in terms of transparency on the operations and decisions of the Partisan Paroles Board. I think that'll be a nice seamless marriage between those two pieces. It's the criminal justice reform aspect of it, and then also the increased transparency. I think will bring pretty heightened reform to not just the philosophy on incarceration going forward, but just the internal operations. I have to think that'll be productive. I mean, do you have any thoughts on that?
I agree, Mr. Chairman. Of course, Representative Tanner's legislation also would allow greater victim input,
Yep.
and many of the reforms involved here are drug offenses sentenced under recidivist treatment. But I agree with the chairman's perspective. I would also note that it's important to note that the district attorneys or sentencing judges would have an opportunity to give input to the Board of Pardons and Paroles under these circumstances. So if there are special circumstances, that opportunity would still exist.
Good. Questions for the committee, from the committee for Mr. F. Mr. Hightower?
If you could, on line 157, and I do believe this is probably just staying in line with some of the criminal justice reform, but why would we change 500 to 1,500?
So for the criminal offense that is it's fraud in obtaining public assistance, food stamps, or Medicaid, the threshold amount that were primarily increased across the board. Existing threshold amounts for felony were $500 for theft by taking and similar offenses, and unless there was another outside reason, they were, for the most part, increased. I wasn't in the General Assembly at the time, but that was across the board. The This offense is just one that was missed or was not included. But increasing the threshold amount here would be consistent with the legislative purpose which was used in the initial phases of criminal
It was,
justice
if I may,
reform.
I think it was in 1176. It was in the initial iteration of criminal justice reform that we updated all of the what we thought we updated all of them.
Gotcha.
And they generally went to 1,500. And if you looked at it, I think they had been set back in the 70s. And so if you just looked at it in terms of the rate of inflation, I think it might have even exceeded 1,500. But we wanted some level of consistency. So I think that's the motivation behind 1,500.
And I understand that, and
Okay.
I guess my concern there at times can be when we do that, we kind of open up a door for these people to know, okay, well, I have a little bit bigger window.
Mm-hmm.
That's sometimes the only concern. They right now because Representative, you know as well as I do that some of the people we deal with in this type of arena, they know the law as well as you and I do as attorneys. And when it gets out that certain things have been up, we run the risk at times that they see a new limit. Does that make sense? And that's my only concern. But I knew this was consistent with changes we made before, and I think we made them to shoplifting and many other issues, if I'm not mistaken. But it was just a concern I had then, and just wanted to ask about it.
I understand completely, and I would also cite the forgery and other fraud statutes that are outside of this that were the thresholds were increased for that. But I certainly understand your point, sir.
I share the concern, and we did at the time of when we did 1176, and that what we thought then, and I think we still collectively think now, is that the real concern came with your organized retail theft cartels,
Yep.
where it's a finely honed operation, and they know exactly what the line is, and a lot of times they'll use minors to go ahead into the malls and to do what they're going to do, and they'll get them, send them to a particular store for particular merchandise and a particular volume, and it's just down to the nth degree, knowing full well, what that threshold is. I share that concern. I mean, that's there, but for purposes of your, random acts, I'm not sure the thought process gets that deep, but on the organized piece, for sure.
And I support the bill. I think it's a good bill, and it needs to be done. Just when we see these, just something I think we need to talk about a little bit, just so we know that it's out there.
Representative Hightower, I agree, and I would mention for the committee, it's still an offense that could be prosecuted by solicitors or by DAs, depending on the jurisdiction. I should mention, Mr. Chairman, that the DA's Association is present here today, supports this legislation. And I've consulted with prosecutors. As the committee knows, I'm a former prosecutor, and I've discussed the legislation with them. Thank you.
Any other questions from members of the committee for Mr. Efstration on House Bill 328? Seeing none, Mr. Efstration, you got off lightly today.
All right. Thank you, Mr. Chairman.
Won't always be that way. Would anyone else like to be heard on House Bill 328? Yes, Mr. Spejas. Well, actually, you know what? There's a lady who was right behind you who actually stood up first in time, first in right. It's what little I remember from the UCC from law school. I think that was it. I think. Ma'am, if you could go ahead and identify yourself, and just if you could just take a few minutes
Yes, sir.
to allow for potential questions. Thank you.
Good afternoon. My name is Sarah Garrity. I'm a lawyer at the Southern Center for Human Rights. The Southern Center is a nonprofit office. We represent indigent people in a variety of cases. I wanted to talk about two provisions of this bill. I apologize in advance. I just had the opportunity to read the sub-language with respect to Section 5. But I did want to let the committee know that from our perspective, there are some extremely distressing changes made to the law, including the elimination of a lot of statutory standards with respect to the representation of indigent people in our state. As we all know, Georgia has a distressing or disturbing history in years past about the quality of indigent defense that we provided to our poor people facing crimes in the state. But in past years, there has been a Blue Ribbon Commission, of course, that recommended a a number of changes. In 2003, the General Assembly made some very sweeping and important changes, implementing a public defender system and making a number of specific changes that this bill would now eliminate. In particular, the bill would eliminate the so-called 3-day rule, the rule that requires a public defender to meet with his or her client, or someone from that office to meet with his or her client promptly upon representation. This bill was born, or this part of the statute was born out of the common experience of people, and our office has represented many such people, of situations where people did not meet their lawyers for months, or even in some case a year after the lawyer was appointed. The Blue Ribbon Commission thought that this was a problem, and it had this, it recommended the language that this bill would now eliminate. So we see that as a concern. In addition, the bill would eliminate the requirement that each circuit public defender establish a juvenile division. This goes in direct contravention to the Blue Ribbon Commission's finding that the state, quote, the state should develop a uniform, effective approach to providing counsel to juvenile defendants. I would also add, and I know my time is short, I'll try to wrap this up, but my guess is that this language comes in response to a currently pending lawsuit. There's actually going to be a hearing on this lawsuit tomorrow before the Fulton County Superior Court, challenging the fairly abysmal quality of indigent defense in a judicial circuit in Georgia. One of the issues in that case is the fact that a number of the young people, juveniles, children facing crimes in that circuit were not getting lawyers. And this bill would, again, eliminate the requirement that the circuit public defender have a dedicated juvenile division. We think that would be a tremendous step backwards, and we'd urge the committee to reconsider that language. Briefly, with respect to I do want to speak in favor of a part of this bill. The part of the bill on page 4 from lines 100 to 125. This is a step in the right direction to reduce the number of nonviolent offenders in Georgia's prisons. Under current law, Georgia's drug possession statute, when combined with the recidivist statute, has resulted in some very lengthy, non-parolable prison sentences for some people convicted of fairly low-level drug crimes. This legislation is in step with other southern states' initiatives to reform parole eligibility for nonviolent offenders. Louisiana passed some quite similar legislation a few years back, and this legislation is modeled on that. It would allow parole consideration, not anybody. It doesn't order anybody's immediate release. It would allow consideration only after someone has served 12 years, and only if they don't have a violent past, and only if they meet a whole host of other narrowing criteria. And we think this strikes a fair balance and ensures that we're judiciously using taxpayer money. Thank you.
Let me ask you a question on
Yes.
the juvenile division
Yes.
piece. And I understand, and I don't recall when that Blue Ribbon Commission was, and I know that obviously that stands in an advisory role.
Yes.
But in some I'm wondering, I'm thinking out loud, do some jurisdictions have the volume that would, I don't know if say justify is the right word, but it would necessitate having a separate division, or could they go ahead and handle that caseload such as it is with existing staff as opposed to creating a new division? I know in some jurisdictions, I'm from Cobb, so I mean that's
Right.
a busy metro circuit, and but some areas and some parts of the state are not going to have that volume, and so does it just from a management standpoint make sense to go ahead and mandate that kind of separate division, or they can just, if they can handle it as is and handle it properly, don't get me wrong, then what's the harm there?
Right. Well, I think the main point is that there be a dedicated juvenile defender, and my understanding is that this language was inserted into the statute all those years ago because that was not the case in many jurisdictions. I think
was that? Let me interrupt.
Yes.
Was that part of the legislation that was adopted during the special session in 2003, where Justice Fletcher was involved with?
Yes, sir.
Okay.
I think that's
Okay.
right, and
All right.
this was a key part of that
2003.
legislation. With respect to your question, one question is what problem is this solving? My strong suspicion is that this language was inserted in order to moot certain claims in a pending lawsuit. I think that is the wrong reason to make a change to a law that was put in place by learned, respected, experienced members of the judiciary and of the government a long time ago in order to try to ensure that children who face terms of detention for crime get quality representation. And for that reason, we'd ask the committee to strongly urge the committee to...
Well, that leads to the question, I mean,
Yes.
does it have to have a separate juvenile prosecutor in order to have quality representation? I'm going to ask Mr. Abstration to respond in just a second if he has any thoughts and wants to. He doesn't have to. But, I mean, that really is the threshold question, isn't it? Well, if you don't have a dedicated juvenile defender, are you able by definition to go ahead and deliver quality work product on behalf of that defendant?
Well,
Right? I mean, is that the question?
that is a serious concern, and
But I mean, isn't that a circuit to circuit decision to be made by the CPD? I don't know what's going on down there. I mean,
Yeah.
I know Sam Merritt, who's the PD
Yeah.
down in Americus.
Yep.
I want Sam to make that decision.
Right.
You know, if he can handle it, he can handle it. But but what his demand down there is going to be different than what it is in Marietta.
Well, again, I think what I would urge is for the members of the committee to find out what is the concern. Is the concern the one that the chairman has expressed, or is there some other concern that's motivating the elimination of this standard and a number of other standards that have been in the law for upwards of 10 years now that from many people's perspectives were a real improvement to...
Well, let me ask Mr. Abstration
Yes, sir.
to speak to that. I can tell you from purposes of the committee, we look at it just like we looked at House Bill 238, which I think everyone, most importantly the CPDs, will tell you brought straight line management and stability to our public defender system. It brought a fair amount of peace. That combined with year-over-year funding, thanks to Governor Deal, candidly, has brought, is the system exactly where it wants to be and should be? Maybe not. Is it a heck of a lot better than it was several years ago? Absolutely. And you talk to any CPD. That's who I talk to. I talk to the CPDs. I say, tell me what's going on.
Yep.
And they say it generationally better. So that's how we're looking at it. That's how I'm looking at it in terms of any particular provision on this. Is that how does it impact the reform
Right.
that we put forward in conjunction with Governor Deal on House Bill 238? Is it taking away? Is it not taking away? I look at it as being a decision made by the CPDs because I want them making that decision. I don't want to make that. I want them making that decision because they know their circuit and they know their job more than I do.
And I'll just close by saying that the elimination of the juvenile division, so to speak, is not the only change to the elimination of a standard. It goes through, this bill goes through and eliminates line by line any reference to standards, caseloads. So I absolutely agree with you, Mr. Chairman, that we are light years ahead of where we were. This bill will take us back.
Let me ask Mr. Abstration to weigh in if he wants to.
I would agree with made as a practitioner from my personal experience as both a juvenile court prosecutor and appointed counsel for indigent or for juvenile court cases. It is my experience that practitioners, attorneys can be very competent to practice criminal defense and practice in areas involving juvenile court cases, and that I would not think that it would be necessary to have a mandate or requirement for public defender's office to make such a designation if competent representation can be offered.
But they can if they want to,
Yes,
if they
sir.
need to. I mean,
Yes,
that
sir.
discretion still is there without the legislative mandate. Is there anything tying their hands? If they wanted to have a dedicated juvenile prosecutor.
Oh, no, sir.
I mean, defender. Sorry.
No, sir.
Okay. And I'm not being argumentative. We're really trying to get our heads around the imperative behind a mandate. And is it, if you can have a mandate, but if you don't have the volume or don't have the volume or the base level foundation to support the mandate, then why have the mandate? As long as you have the discretion within the office, as long as Sam Merritt down in Americus If he feels he needs to have a dedicated juvenile defender, fine. And within the confines of the next director of the Public Defender Standards Council, that office, they work together pursuant to the straight line management of 238 to establish what it is that they need with the funding that they have, hopefully increasing year over year over year. I hope that's reasonable.
I would just close. I know the time is limited. I would just close by saying that most respectfully that in the past, leaving things to local control in this particular context has not been effective, and the language in the proposed bill. The bill would take out the language, each circuit public defender shall establish a juvenile division within the office to specialize in the defense of juveniles. And so this would eliminate that effort approved again by the Blue Ribbon Commission so many years ago to ensure that within the public defender office, children get the special attention that they need. Juvenile law is different than adult criminal law, and that children get the quality representation that they need.
Well, for now, we may have to agree to disagree because
Yes, sir.
it doesn't, with all due respect to the Blue Ribbon Commission of 2002 and 2003, and I voted on that bill, House Bill 1EX, during the special session that summer. We have the benefit of 11 years of experience, since then, and we've come a long way since then. We have a little longer to go, but we've come a long way.
Agreed.
To say that, you don't trust the local control is essentially saying you don't trust the local CPD to communicate with the next director to say, hey, I need a dedicated, juvenile defender here. Work with me on, because it's all funding. I mean, it comes down to the funding of, can we bring in a dedicated person to do that? That's going to, again, that's a budgetary management issue. I'm using Sam Merrick because he's my law school classmate and a friend of mine from Americus who's down there doing a great job.
Absolutely.
That's for him to have that conversation with the next director to work that out. That ultimately goes in front of Alex Atwood, right? To make sure that funding gets there, and the General Assembly, and of course the governor, to effectuate that. But it doesn't tie their hands to not do it, and that's what I really want to see more than anything else. It's just if they need it, get it. If they don't need it, then they don't need it. And I do think that the local CPD ought to make that decision in conjunction with the director. That's good management, and it's getting ahead of the curve and managing the budget that they have. We may agree to disagree on that. I think a mandate is great when there's a universal accepted, this has got to happen and here's why. But to me, it's a circuit-by-circuit conversation. But I hope that's reasonable. Mr. Trammell.
Mr. Chairman, if the chair would indulge me, the testimony raised some questions that I would have for the author. Sure. And the first question would be about the elimination of on lines 432 to 435 of the bill.
Sure. Or you can be there, whatever's comfortable.
Shall I return, Mr. Chairman?
Thank you.
Thank you.
The testimony that we just heard about the elimination, first would be lines 432 to 435, which seems to eliminate the provision that would just say that attorneys who seek appointment have the necessary experience to handle the case to which they're appointed. And in question being just what the thinking is behind taking that provision out.
Sorry, I was looking at the incorrect line. So the problem that's occurred is in conflict cases, as I understand it, there was a case law that made a determination about the requirement for public defenders to bring in conflict counsel that was in place. And because of that issue, that was, I guess, outstanding. This provision isn't necessary, is is my understanding. It would allow for, and I'm happy to investigate this further, Representative, and let you know. But in dealing with the conflict issue that was out there, allowing for ensuring that proper oversight and the proper forms that we've seen and the great benefit that we've seen over the years since indigent defense was implemented, that we're able to make those successes permanent here in the code.
If you don't mind looking into that, I would appreciate it, because
Yes, sir.
I can see how, as the prior testimony, this could be read to eliminate a standard that basically says we just need to have a baseline competency for conflict defenders who seek appointment.
I'm happy to look into it and get the specific reasoning there. Of course, a practitioner would need to be competent in the area in order to provide sufficient representation, of course.
Mr. Chairman, if I might ask one more question.
Sure.
And then if I could ask about the other standard, which the previous testimony alluded to, which is at line 450 to 454, the 3-day requirement. Can you kind of walk me through what the thinking is on taking that out?
The 3-day requirement, specifically, I can provide maybe some examples to you, and I can just tell you from my practice experience that 3-day requirement many times might not be is a parameter within which meetings should take place, but there might not be a recourse that's in place currently if the attorney fails to meet within 3 days. But as to the specific provisions here, I'm happy to look into that and maybe meet with you to discuss all this before the committee considers the bill again.
Thank you, Mr. Chairman.
Any other questions from members of the committee? Seeing none, would anyone else like to be heard on House Bill 328? Mr. Spehouse, you were just a hair behind before. That's what we just. But you were in the on-deck circle. I apologize, I forgot.
That's fine. I've been called slow before. Thank you, Mr. Chairman. I just specifically want to address Section 2.2. There's been some conversation about this. As the chairman and the members of the committee know, we've worked very closely with Representative Tanner on the pardon and parole bill as we were discussed. And I would be remiss if I don't come in and thank Judge Boggs for this being in the posture that it's in. When this concept was first floated, we looked at it. There were some serious concerns about the way the initial concepts were put together. In our opinion, the DA's Association and Prosecuting Attorneys Council, the way this provision is written, it honestly gets to some drug offenders that, quite frankly, are left behind by what the criminal justice reform has accomplished. This is a sound mechanism of reaching some of those offenders, and it does put protections in place to make sure we're not talking about violent offenders, we're not talking about sex offenders, we're talking about multiple drug offenders that don't have that kind of history. We appreciate the council working with us to get this drawn narrow enough that it gets a population that we're comfortable with, and we do support that concept.
Thank you. I appreciate it. And the Prosecuting Attorneys Council has been a tremendous resource in this multi-year effort, and just making sure, number one, that things functionally work, and that we're really getting to the people who we need to get to, under this philosophical, approach of smart on a crime. But, what have we said out there? We've said, look, we want, there are people who are just taking up beds that need to be reserved for violent offenders. And so let's be very careful as to how we pick and choose how we do that. And this is a statute that illustrates that. And appreciate your personal assistance on this and everything else that's been related to it, because it's invaluable. The road to ruin is paved with good intentions sometimes. So we take our time and we get it tight and we get it right. And you're a big part of that, and we appreciate it.
Yes, sir.
Thanks, sir. Thank you. Any questions, Mr. Spehouse? Thank you. Would anyone else like to be heard? Ms. Michaels.
Thank you. You can hear me from here, right? So,
Oh,
yeah, I know.
you know.
Thank you so much. Sandra Michaels with Georgia.
But you know what? For purposes of the broadcast, it actually would be better. Thank you. That's all right. We're fine.
Sandra Michaels with the Georgia Association of Criminal Defense Lawyers, and thank you very much. And we also thank Judge Boggs. He's been extremely helpful and receptive in meeting with us and taking language. I'm not going to repeat everything that Ms. Garrity already spoke about, but as the chair knows, that we worked very hard in 2002, 2003 on a lot of these issues. GACDL is not involved in any lawsuit whatsoever. I want to make that very clear. But I would say that we spent an enormous amount of time on section 450 through 454, which is the 3 business day. And I would just very much urge this committee to reconsider removing part of these rules. We had situations across the state where people were sitting in jail for almost a year, sometimes over a year, without ever seeing a defender. And it pains me as a criminal defense lawyer to admit that, but we were having problems, and these rules put it in place. 3 days is not unreasonable. I think we were, that it was negotiated, and 3 days was considered a fair amount of time before someone to go see them. And I understand, I agree, Sam Merritt's fantastic. I've not had a chance to vet this new section before our members, or even people like Sam, and I really would like the opportunity to talk to them a little bit about some of these rules that they're getting rid of. There may be other issues, but that was one that struck me as one that we would prefer not removed. And our association would be happy to work with anyone on meeting on this.
Okay.
Thank you.
Question from Mr. Pack.
Sir.
I was going to ask you about another section, if that's okay.
If I can respond, I will.
On line 434 to 435, related to the qualifications and standards for representation of indigent defendants, what are the qualifications and standards, if you can remind me? Maybe Ms. Garrity can answer that.
Yeah, I was going to say, we actually weren't involved in that. Yeah. I mean, I think it's mainly what you're required to do.
They have a bar card?
Well, I don't know, because I'm not involved. We're not involved in that. They're a very separate association than we are. Are you talking about the standards?
Yeah, it looks like there's standards set by the council, and I don't know off the top of my head what those standards are.
I'm assuming it's the specialized training, at least taking some public defender training like it is for the federal defenders program, having some training of evidence, the ethics, I think the same as CLE, but geared towards representing a criminal defendant. And that's certainly what it is for federal public defenders. But specifically the actual training they have to receive, I'm not sure.
And if I may follow up, Mr. Chair, the section that you questioned about, Ms. Michaels, the 3-day rule, I think Representative Efstration brought up a good point. What is the recourse for someone who is stuck there for longer than the 3 days without having a lawyer visit them?
I'm not sure what their recourse is. I think this was basically putting in standards and policies for the public defenders to follow. I'm sure, I don't know what they would do.
I mean, would they be sued for not doing that, or what?
I don't think they could be sued.
So,
but I don't know.
So because of that every now everybody complies with the 3-day rule?
I mean, I have no way of checking on that, but my understanding is that was definitely, the 3 days were put in there and agreed upon by the public defenders, the CPDs, and everyone, that was a reasonable amount of time to require them. And as Ms. Garrity said, the problem was, and I think the chairman pointed out, there's all across the state, there's different issues in each department. And that was one everyone agreed upon, that they need to be seeing their clients within 3 days. It was a huge problem, and it did not look well on our defense for be waiting that long to see a client that's been sitting in jail.
Thank you.
Thank you.
Thank you, Ms. Michaels. Would anyone else like to be heard on House Bill 328? Speak now. Okay. Members of the committee, thank you. I think, again, what we'll do is, as we consider changes for substitutes for both of the bills today, we will look to have that either on Monday or Wednesday at the latest of next week. If you have any comments you'd like to make, send them my way. If there are any comments from interested parties, they should please address them to me directly. You can just email it. There's no filter or anything like that. It goes right to me. And we'll also, House Bill 103, just to bring to your attention, House Bill 103 was recommitted from rules. I was not there this morning. And there was a respectful request from a member of the committee for us to reconsider, or to consider again, I should say, our position on the merger language. And the substitute that you have here, I don't think, I'm looking to see if it has, I think the merger language was taken out of it. It's out, yeah. So this is a substitute that was where the merger language was taken out. This, of course, applies to a depiction of a minor in an obscene depiction. The committee, in its wisdom when we passed it out, I believe on purpose, had that merger language, the non-merger language, in there, given the seriousness of the issue. There was a respectful request for us to take another look at that. The way the chair is going to approach that is to obey the will of the committee on that. And of course, we'll have a little bit of a debate on that on Monday at our meeting. My sense of it is that our not allowing merger, given the seriousness of the offense, was very much on purpose. My sense is that we'll stick to that position on Monday, but I'm going to leave it to the will of the committee as to how we approach that. I'd like to have a good, vigorous conversation on that so that we can have a good, strong position, whichever one it is, as it makes its way to the floor. I know Mr. Reeves has been doing some research on it, and we'll hear from him on Monday when we consider HB 103. So with that, thank you for being here. We are adjourned, and thank you to members of the audience for being here.